Good morning, Martin Scheinin, Professor at the European University Institute and Head of the SURVEILLE project. I'd like to ask you some questions about the NSA PRISM JCHQ's revelations. So thank you for being here.
Thank you.
I'd like to ask you in particular whether these revelations, whether any of these revelations or discussions about the revelations were surprising for you.
As to the revelations themselves, the most surprising thing was really the volume of the surveillance. I think there was good grounds to suspect that our internet use and our telecommunications are not totally safe. And it was good reason to think that the Americans were being quite hypocritical when they were criticizing Europe for its data retention. We have seen that the volume was unexpectedly massive. So basically all internet traffic is being trawled in order to be analyzed later. In the discussion, I'm very surprised how open the leading politicians, judges, oversight authorities have been in admitting their incompetence. In, for instance, the FISA court head judge saying we don't have capacity to exercise our oversight, congressmen entrusted with oversight functions saying we don't have the capacity to exercise oversight, legislators saying we don't know what we legislated, and then the executive simply saying, well, we did it, but so do others. I'm surprised that there are no more sophisticated answers when they are caught from what they did.
So this leads me to the second question, which is whether the member states of the European Union can adopt any legal measures to protect themselves against the mass surveillance like PRISM.
Well, of course, yes. There's the special EU-US relationship, which will need to be reconsidered. And there are all kinds of proposals how to include legal safeguards in agreements with the United States of America. Some of them may be politically impossible, some of them may be economically dangerous for the EU itself, but certainly there's a wide range of options to consider. Then another thing is that the EU should not forget international law and the fact that there are certain measures, and one could think of taking the issue to some sort of legal forum, for instance, under the interstate complaint of the Covenant on Civil and Political Rights, or trying to get the United States back to the International Court of Justice with a carefully formulated case where they would accept exceptionally the jurisdiction of the court. I don't think those should be dismissed. A complication, of course, is the deep involvement of UK authorities, the signals intelligence and the government in many different ways.
Talking about the Covenant, the Chancellor of Germany, Angela Merkel, proposed to adopt a new protocol to the Covenant exactly to take into account data protection issues. And there have been suggestions regarding a review of the general comment on Article 17. Do you think that this would be a useful approach?
Well, the idea of an additional protocol to the Covenant on Civil and Political Rights is unnecessary and outdated. The Covenant has a provision on right to privacy and family life and correspondence and honor and reputation, so it's all there. It's only a question of interpretation. Already the old existing general comment by the Human Rights Committee clearly shows that it is capable of being adjusted and interpreted also in the modern era of telecommunications and internet. So there's no fundamental gap in the protection as to international human rights law, and therefore other people, including myself as Special Rapporteur on Human Rights and Counterterrorism and the current Special Rapporteur on Freedom of Expression, have proposed going the way of simply codifying the current understanding of the provision through a so-called general comment by the Human Rights Committee. A general comment is an authoritative statement of the law, but the law itself is in the covenant already. I think the additional protocol idea is a bad one because, first of all, it would be difficult to negotiate in the current political climate, and even if successful, states would only choose whether to ratify or not, and in this way probably weaken the current obligation by saying the new protocol governs e-privacy, we didn't sign up to that, so we don't have an obligation. So I think it's a bad idea, but it needs to be reformulated because certainly there is need for better understanding of international standards in the field of privacy, and I think the general comment by the Human Rights Committee would be a good way ahead, maybe coupled with a political declaration adopted at higher United Nations level, not as substitute for legal measures, but just to draw more attention to the matter.
The European Parliament has recently launched an inquiry into the NSA JCHQ's revelations. Do you think that it is useful, and if so, what should it address exactly?
It's certainly useful to have an inquiry, and I think one area of focus needs to be EU's own normative framework, including its relations with the United States. And there, of course, the European Parliament has a real say. They are involved in deciding about improvement of the law. So that should be one area of focus, but also the European Parliament should put pressure what the EU does at the level of international law in relation to the United States, for instance, whether to open some sort of a case at an international forum.
Thank you very much.